Welcome back to Law and Crime, everybody. I'm Jesse Weber, and thanks for joining us. Our focus right now is going to be on our live trial of the day out of California. Let's talk about it. Joining us right now is trial attorney Andrew Cherkasky, who's going to provide some perspective on this. Now, Andrew, based upon what I was just listening to in the defense's opening statement, they're saying, in my opinion, A, there's nothing irregular about this relationship between Joseph and Charles. The idea that, you know, he had access to these accounts. There's nothing irregular. He knew what was going on. But Dan Kavanaugh, the person that they are pointing the finger at, saying that investigators really didn't thoroughly look at, he might have been the one who was improperly manipulating this account. And at one point, I thought I heard it suggested throughout this case that Joseph and Charles were trying to kick out Dan and protect those accounts from Dan Kavanaugh. I'm curious your perspective on this alternative suspect theory.
Well, one of the things that you have to remember going into it is that it's been very criticized of the prosecution as it starts that the dollar figure, $40,000 or so, isn't enough for a motive to commit a crime of this sort. So even as we go past that idea, now we're starting to talk about, okay, what are the details of it? The defense is doing a fine job in their opening of establishing that what's going on are very normal business practices. Checks are getting cut, business dealings on QuickBooks is being transferred from one place to the other. These are not suspicious activities as the prosecution wants you to believe. It's relatively effective as the defense is presenting it.
What's interesting, though, is both the prosecution and the defense seem to be suggesting this financial motive. So it's not like the defense can come out and just say, my gosh, you know, who would kill a whole family for this amount of money? Oh, wait, but at the same time, Dan Kavanaugh would do that, right? They're limited in their defense in a way.
I think you make a great point. The nuance to that would be, I think the defense is saying, well, if somebody was going to do this for that amount of money, look at Dan Kavanaugh. I don't know that the defense is going to be putting on the sort of case that you see in some instances where they're putting on forensic evidence that literally links it to the other person. This is more of a, even if you believe this theory of motive, look at this other person who had the equal amount of motive.
Well, this week was interesting about this QuickBooks account because Ryan Baker, who's a former QuickBooks representative, he didn't quite take the stand. He testified via Skype. He was unavailable to be in that courtroom, but he provided very interesting testimony about something that seems strange. And who did he speak to? Let's see.
Okay, so there's additional steps that have to be followed in order for that to occur. Is that right? So someone calls you and indicates that they are Joseph McStay and they want to delete their account. What was the next step that you took?
The next step that I took was I told them that I was going to send them an email, that they needed to fill out the email and send it back to me, and then we would start the process of removing the information from the servers.
And would that email have been sent to the custom@earthinspiredproducts.com account?
Yes, ma'am.
And can you tell us essentially what the email says that you send out?
The email is basically just a small protection that says, you know, you can please fill out this email that says my name, or you would fill in your own name. You hereby get permission for QuickBooks to delete all the information for business names, and they would fill that information out and send it back to me that they give permission to do that. They can purchase another version or another subscription with another email or anything like that, or, you know, walk into a store.
Okay.
And QuickBooks.
And do you recall what any, is there a set line that QuickBooks uses for customer service calls?
Okay, Andrew, I want to get your thoughts on this, right? So this QuickBooks representative is contacted after the McStays disappear by someone who's basically impersonating Joseph McStay in an attempt to close out the accounts. So he sends this email to Joseph McStay's account, and he doesn't get a response back. He finally closes the request. What we know is that about a year ago, a detective had testified in a preliminary hearing that the phone number was traced to Charles Merritt. The jury hasn't heard this yet. What do you make of this series of events?
This is one of the pieces of evidence that I think is troubling for the defense in this case, because it does play into that idea that he may have been trying to do something behind the scenes to take control of the money, or to at least obfuscate or delete something that had happened. So I think that it is a problem for the defense. On the other side, it could be that these are all community type based business practices, and they're each working one with the other to do something that they're trying to get done.
Can the prosecution secure a conviction just if they can show that after the McStays disappeared, Charles Merritt was extremely dishonest and shady? If they can show that, is that enough to convince a jury that he committed this crime?
Well, consciousness of guilt is what you're talking about. The idea that a defendant acted with a consciousness of guilt often gets people convicted. There's circumstantial evidence, but the circumstantial evidence comes down to what was it that the accused or the defendant was doing that made him look guilty or made him look like he thought he was guilty. In this case, that's a possibility. I haven't seen enough of that yet, but consciousness of guilt certainly gets people convicted all the time.
Yeah, we've seen it. We've seen it. I'm curious how it'll play out in this case. Still, there's a long way to go. And when we come back, we're going to play the cross-examination of this QuickBooks representative. So stay tuned here on Law and Crime. We'll be right back. I know it seems a bit strange that witness wasn't in the courtroom. He had to Skype in, but really the substance of it doesn't change. Andrew, what was the defense trying to do under cross-examination there of this key prosecution witness? What were they trying to get at? Okay, so I think we're working on some audio right there with Andrew. In the meantime, let's continue on with this witness for the redirect, where he explains what he found odd about the phone call.
Anything else, Ms. Rodriguez?
Yes. Mr. Baker, you indicated that you had reviewed a message or some notes regarding a call on the 8th. Do you recall that?
Yes, ma'am.
Do you have any information that a transfer actually took place of the data on the 8th?
No, ma'am.
And were you able to determine from the email that you read whether a disk was actually sent out for QuickBooks on the 8th?
No, ma'am.
Okay. Knowing that a phone call came in for a transfer of data on the 8th, and then still receiving that phone call on the 9th asking for deletion of data, do you still find that call to be unusual on the 9th?
Yes, ma'am, very.
Why?
Most business owners and anyone who has their data anywhere in a cloud or anywhere like that, the main thing that's worried about is protection. They don't want anything to happen to their data. What if something goes wrong? What's my contingency? What's my backup? What's my backup of a backup? This is my company information. It's my livelihood. That's what most people tend to think about it and at least perceive off in their phone call.
Now, if somebody puts a desktop version on, there's also the ability to access that online. Is that correct?
That is correct, yes, ma'am.
And you indicated that you would, I know there was a good deal amount of time spent on a particular slide with all of Mr. McStay's accounts, but the notes that you made and the information that you made for that caller had the specific email address of custom@earthinspiredproducts.com. Is that correct?
Yes, ma'am.
And the caller indicated to you that he was Joseph McStay, correct?
Yes, ma'am.
And in terms of the data, I don't think you got to finish your answer, but you indicated there was a difference between exporting data and deleting data. Can you explain what you meant by that?
Yeah, the data can be exported once it...
Okay, now we have Andrew back with us. Andrew, let's start with the defense. Okay, the important witness for the prosecution saying this odd behavior, especially under redirect, saying who would delete this information and who would impersonate Joseph McStay. What did the defense try to do under cross-examination here?
What they were trying to do is narrow in on a theory that they've been focusing in on throughout the entire case. The passage of time has caused certain evidence to disappear. With the QuickBooks, it's the fact that these recordings no longer exist, as far as I know. And we're just dealing with the memory of the individual and the notes that were taken in the system. That's what they're looking at.
Now, that seems to tie into another one of their theories, which we've seen a lot before. The prosecution, investigators looked so carefully at Charles Merritt that maybe their focus was a little too narrow, and they didn't look at other suspects, in particular Dan Kavanaugh. We've seen this in other trials before where investigators are accused of having too narrow a scope. Do you think that's a fair argument here? Do you think that they didn't look far enough at other suspects? Did they just want to get Charles Merritt? Because some of the criticism in this case is there's not a lot tying him to the murder.
What you're talking about is a concept known as confirmation bias. Once you suspect something, you keep looking for it and you're going to find more evidence of it. If you start to look for yellow cars, you're going to see yellow cars all day long. In this case, I think that there is some evidence of a confirmation bias. They started with someone who was most closely attached, someone they thought had the financial connection. I don't know that they did as thorough of a job as they could have in just doing blanket canvassing. They did a thorough and good job. I don't know if they've eliminated the defense's ability to effectively ask those questions of who else it could have been, though.
The defense is kind of limited. They can't introduce these text message exchanges between Kavanaugh and another business associate where it shows him threatening. They can't introduce communications between Kavanaugh and Joseph McStay. So can they introduce, when they ultimately get the case, that investigators didn't look at other suspects, that their investigation was limited? Can they show that?
Sure. The idea of what investigators didn't do is a key function of any defense counsel. I'd be shocked if a judge didn't allow a defense team to go through a laundry list of items that the investigators didn't do. And they've been doing a fine job of it in cross-examination. Also in argument, in closing arguments, what didn't they do? Asking those questions of what the government didn't do to answer all of the theoretical questions. That's the idea of what reasonable doubt is.
Well, I'll tell you one thing that investigators do. They combed that gravesite where the bodies were found. And we're going to talk more about that gravesite and its possible connection to the defendant right after this. Stay tuned. Welcome back, everybody. We're talking about the Charles Merritt case. We are delayed in that courtroom because apparently a juror got into an accident. We'll update you as soon as we have more information. In the meantime, we're recapping testimony that you may have missed, and now we want to focus on the gravesite where the 4 bodies were found. Now, if you're the prosecution, you really want to tie Charles Merritt to that gravesite. And what you also want to do is say that the killings happened in the McStay family home, and that family was then moved to that gravesite. How have they done that? Because there are some pieces of evidence that may connect the gravesite to the home. Let's see the testimony of Joseph Steers, who's a former San Bernardino County detective who can talk more about this.
It's a picture of a beige woven cloth material consistent with what was pictured in the previous exhibit number 93 and the photographs that were seen of the futon that had its cover on.
Check the foundation. Exhibit number 262, is that the sole and exclusive picture of fabric material taken from the excavation site?
No.
Was there numerous?
Yes.
Okay, so at this point it's an exemplar, just a single reference point. Exhibit number 48 and 83. Do you recognize those 2 photographs?
Yes, I do.
How are you familiar with those?
These are photographs I reviewed again from the San Diego Sheriff's Department. They served a search warrant at the McStay residence in Fall River.
And why did you single out exhibits 48 and 83 in your evaluation of the case at that time?
There was presence of paint cans in 48 on the bottom right corner, along with some painting supplies above it. And in 83, in the garage, there's a couple paint cans, I think, on the right side.
And what is that on top of the box to the left in 83?
Additional paint supplies.
Okay. And to your knowledge, was there also another paint can documented in the house somewhere?
Yes, I believe the laundry room.
Okay. Based on that, looking at exhibits number 250 and 348, I believe, if I read that right and correct. Do you recognize those two items?
Yes, I do.
And how are you familiar with them?
There are photographs of Summer Estates Reserve found in the gravesite and the Stanley sledgehammer found in the gravesite.
And how was that significant to you in evaluating this case in the beginning?
Both items had what appeared to be the paint smudge on them. The bra had what appeared to be paint going horizontally across it, and then there was a paint smudge on the handle of the Stanley sledgehammer. And those are consistent with the painting at the residence in Fallbrook.
Objection, foundation.
Are you aware whether the hammer and the bra, what appeared to be paint, was sampled and sent off for further testing?
Let's break this down right now with trial attorney Andrew Cherkasky. Andrew, how important is it to establish that the killings happened at the home? Can they, and clearly they're showing there's some evidence backing that up, that there's, these items seem to be related to the home, and especially the paint. So if it's at least possible the killings happened there.
On Law and Crime, they're going a bit far. To them it seems like they think it's necessary to say that it must have happened in the home. I'm not sure why they're so insistent on that.
Well, is the idea that who had access to that home? Would it be a complete stranger, or would it be somebody like Mr. Merritt, who was very familiar with that house and maybe had access to the house and knew Joseph McStay? It seems more likely than not.
Well, it certainly does lower the pool of people who were potential subjects or suspects in the murder. The problem for the prosecution is they don't have the blood spattering. They don't have the direct evidence that he was there at a time that this occurred. They don't have the materials that would be over the top that would definitely connect it. So my fear for the prosecution is they're overpromising. And once you overpromise in the minds of the jury and you fail on one of the promises, you lose credibility.
That's a good point. Let's continue on with Joseph Steers, and we can learn a little bit more from the gravesite.
Are you familiar with that?
Yes.
How are you familiar with that?
It's a photograph I reviewed from the San Diego Sheriff's Department at the time we served the search warrant at the Fallbrook residence, depicting blue painter's tape around the door frame and walls to the downstairs bathroom.
And Exhibit 364? I don't have it displayed yet.
364 is a clump of material that was found on the gravesite where the estates were found in Victorville, which also had what appeared to be the same type of blue painter's tape wrapped in it.
Objection is foundation, hearsay, and speculation.
That there appears to be blue painter's tape?
Yes.
Your Honor, objection, foundation, and speculation.
Showing you exhibit number 267 and 268. You recognize that?
Yes. Yes, I do.
How are you familiar with them?
One is, number 267 is a black backpack found in the gravesite of the in Victorville, and 268 were 3 items: a paintbrush, a spoon, and a small little paint type item that was also found in the gravesite.
Okay, some more items linking from the gravesite to the house. Andrew, let me just start with this question that I didn't ask you before. Are they establishing a strong case that the killings did in fact happen at the house?
They're establishing a strong case that there's a connection between leaving the house and getting ultimately to the gravesite. I still don't see the evidence of a murder at the home, especially of 4 people. There's not enough blood. Now, earlier in testimony, there's already been explanations that you might not expect to see as much blood as you might think of it in a TV show, but it is awfully clean.
Yeah, you're talking about one of the experts that testified that based upon those injuries, you might not have all that blood everywhere. But two things to consider. There was a little bit of blood, what we thought might be blood spatter on one of the kitchen tables. The lead investigator says it could be blood, might be blood, but ultimately he doesn't think the killing happened there. The other idea is if there was paint in the house, couldn't someone just paint over everything?
Well, 2 points. First, to the table issue. There was testimony that when looking at the table with the flash of the camera, that you could see some spattering. Now, that wasn't tested and it wasn't confirmed to be blood, and there was actually some fighting going on in court about whether that would even be admissible. The judge allowed it. I am not convinced by it. I don't think a jury is going to be convinced by it, especially after having watched a few CSI episodes. Not that that's the state of the science, but it's what you expect to see. The other piece of it is, can you just paint over some blood on the walls? I'm not an expert. I've been around the block in the criminal world for some time, and in my experience, that's the sort of thing that investigators can tend to find evidence of. So I'm not convinced that either show a good explanation of why there's no blood spattering.
And listen, I don't mean to speculate, but sometimes that's what we have to do here because we don't have a lot of answers. We don't have definitive answers. And maybe we'll get some more answers from Diana Wright, who's an FBI forensic examiner that testified earlier in this case about the items in question. Take a look.
The items, correct?
So when I tested them.
You saw the actual items or you saw scrapings from it?
I saw scrapings from the items.
So this is an item that's the sledgehammer that the scrapings came from that you tested for one of the two items. And this is the bra. The bra is more important to me, since you are an expert on paint. They described the paint on the bra in the report submitted to you as a drop on the bra. Looking at 746A, would you consider that just a drop?
Objection, argumentative, calls for speculation.
Overruled. You want me to say this is a drop of paint?
How would you describe that paint on the bra before you in 746A?
How would I describe this paint?
Would it be more than a drop?
Objection, argumentative.
Overruled. Depending on how much was splashed onto it, it could be one drop, right? It's paint on the bra.
Is that, because you talked about based on your analysis of that item, that the paint went onto that item and likely cured by air.
Objection, speculation, foundation.
Overruled, she can answer if she has an opinion on that.
Did you read the question?
In your report, you talked about how the paint scraping that you analyzed, it appeared to be paint that was on that item and cured by air.
I would agree with that.
Well, what does that mean when you put in your report that it's cured by air?
What I mean is that I believe that this paint was wet when it was dropped onto the bra, and that's how it got on here. Dropped on and then dried.
And if something else, say the hammer came in contact with the bra, when it's still wet, would that be allowed to transfer onto the hammer?
Objection, speculation.
Overruled, she can answer if she has an opinion.
If paint is wet and something else touches it, yes, I think it can transfer.
And that can be from direct transfer or me touching something that's wet and then touching something else with my hands still wet with that, correct?
Depending on how much paint would be on your hands, yes.
And do you see any paint on the handle of that sledgehammer that would be consistent with what you tested? If you could take a look and see.
Object as to speculation and foundation.
Overruled, she can look at it and see if she has an opinion.
So I have pictures of these items in my notes that I was using as well.
Do you have those notes with you?
Those notes were provided in discovery.
No, but do you have them with you? In case you need them for reference, because I have them.
I have a copy of my notes.
Okay. And if you need to refer to your notes to help kind of refresh your memory and maybe where it came from.
Okay, we're still trying to get answers as to where the family was ultimately killed. Andrew, to take a step back, one of the things that's always bothered me in the case, and I'm curious if it's bothered you, is the fact that the sledgehammer was left with the bodies. We've seen so many cases where the murder weapon is tossed away from where the bodies are found. Did anything strike you as odd about that?
Well, it's not necessarily that it's odd. I mean, there's a couple of different ways to think about the psychology of a murderer. One being that you bury the bodies assuming that they'll never be found. If that's the psychology of it, you typically can hope or think to see that you will find the murder weapon at or near that same site. The other idea is you try to spread things out because you don't think that, or you do think that they'll eventually find the bodies, and so you don't want them to find the whole cache of evidence there.
Yeah, but I guess the idea here is, and you mentioned the psychology of the killer, the idea that someone would kill not just Joseph McStay, but his entire family, does that tell you something about the killer as well?
Well, again, I mean, this is something that goes into the forensic psychology and really would be the truth detecting that wouldn't be allowed in court. But to me, the idea of killing an entire family means that the entire family has the evidence, or this is a crime of passion of some sort, that there was so much anger and passion filled that they just didn't stop. It's no different than seeing a murder with many dozens of stab wounds versus a few stab wounds. It's that evidence of a crime of passion.
Yeah, and one of the other aspects is the fact that Joseph McStay's body was different than the other ones. He was the only one who appeared to be wrapped up in something, and there was no lower portion of his body. Again, there's a discrepancy between him and the family.
That's right. I mean, the facts of what happened in that situation and the brutality in which the crime occurred, it's not being answered particularly well. It's a fact, but it's not answered as to why at this point. $40,000, I'm not sure that does it.
And you're talking about passion. One of the things we saw in Charles Merritt's interrogation tape was that he did speak a little harshly about Summer McStay and also kind of said that the kids were a little wild. Not that should be read into, but it's something to think about. We're going to take a break, but when we come back, we're going to hear from Charles Merritt's former employee. We'll be right back.